Good afternoon. Attorney Protective would like to welcome you to today's webinar, To Infinity and Beyond, Using AI in Your Practice. Please reference your materials for information about today's speakers, Joe Salvati and Erin McCartney. With that, I would like to introduce your first speaker, Erin.
Great. Thanks so much, Kate, and thank you everyone for joining us today. I'm quickly going to just look at the agenda and cover what Joe and I plan to cover today. You'll see that we'll talk about GAI. We're going to talk about different types and the players that are out there today. How do law firms feel about AI? Some of the risks that are associated with using AI as far as hallucination, risks to confidentiality and IP infringement. And then we're also going to cover some cautionary lessons to be learned, and then end with some internal policies to consider, and then also some guidelines on what AI can be used for in the practice of law, and then also what it should not be used for. So with that, let's talk about what is GAI. GAI is short for Generative Artificial Intelligence, and it's a type of AI that can generate new content, like text, images, audio, and video. Unlike traditional AI, which performs specific tasks based on instructions, GAI creates novel content by learning patterns and structures from large data sets. AI-powered legal research platforms offer features like natural language search, predictive analysis, and document review assistance, enabling legal professionals to find relevant information faster and more efficiently. Generative AI is being increasingly used by law firms to automate tasks, streamline workflows, and improve efficiency. LexisNexis and Westlaw, they both have incorporated AI into their platforms, offering tools like Lexis Plus AI and Westlaw Precision. Now, these tools utilize generative AI and large language models to provide comprehensive research capabilities, including case law and document drafting assistance. I'm quickly going to cover some of the benefits of GAI for law firms. GAI can automate repetitive tasks like legal research, drafting documents, and summarizing information, freeing up attorneys to focus on higher-level strategic work. By automating tasks and potentially reducing attorney hours, it can help law firms reduce costs and improve profitability. It can help automate and improve the efficiency of various legal processes, such as document review, e-discovery, and client communication. And GAI can help law firms provide more accurate, timely, and efficient legal services to clients. It can be used to conduct legal research, analyze data, and identify relevant precedents and statutes, helping lawyers make more informed decisions. So this all sounds great, but while GAI offers numerous benefits, it also raises ethical concerns that legal professionals must carefully consider, such as our duty of competence. Attorneys must ensure that GAI-generated outputs are accurate, reliable, and trustworthy before relying on them in legal representation. Client confidentiality. Law firms must take steps to protect client confidentiality when using GAI tools, particularly those that may learn from or retain that client data. Transparency and disclosure. Law firms may need to disclose the use of GAI to clients, particularly when GAI outputs will significantly impact client representation or billing practices. Candor towards the tribunal. Attorneys must ensure that any GAI-generated content used in court filings is accurate and truthful, and they must disclose any use of GAI to the court when required. And we're actually going to talk about this in a lot more detail when we talk about some specific cases where lawyers got themselves into some trouble. So stay tuned on this one. And then fairness and bias. GAI tools may be susceptible to bias, and attorneys must take steps to ensure that GAI does not perpetuate unfair or discriminatory practices. And we're going to talk about biases with GAI in a little bit more detail later in the presentation as well. But first, let's turn to how do lawyers feel about AI? So this information on your slide is taken from the most recent legal trend report published by Clio. And this report analyzed data from tens of thousands of legal professionals in the U.S. And it really provides important insight about how technology is currently being used by legal professionals, as well as its impact on firm performance. As you can see on the slide, The report indicated that the vast majority of lawyers have adopted AI in some capacity. While 79% of firms have adopted AI, the number that have adopted it universally is just at about 8%, while another 17% say they have adopted it widely. And then 34% say they've adopted it only minimally, and 21% say they've adopted it partially. But just for some perspective, when they researched AI usage in 2023, only 19% of law firms were using AI in their practice. So over the last just couple of years, this number has skyrocketed. When lawyers were surveyed about why they are using GAI for their practice, here's what they said. They said for legal research, GAI can be used quickly to research legal issues, identify relevant precedents, and analyze case law. They're also using it for document drafting. They said GAI can help attorneys draft various legal documents, including pleadings, contracts, and briefs. They're using it for e-discovery. They said it can be used to review and analyze large volumes of documents in e-discovery, helping identify relevant information and reduce costs. They're also using it for client alerts. They said GAI can be used to generate client alerts about regulatory changes and statutory updates, helping lawyers keep clients informed. And then they're also using it for marketing and business development. GAI can be used to create marketing materials, generate content for social media, and also help improve client relations. So on the next slide, you'll see universal adoption of AI is still low. So why are lawyers holding back on adopting AI? You'll see 59% said they're unsure it will help them in their work. And then another 44% said that they don't trust it. We have 34% saying they think it's unreliable. And then you have 30% saying that they don't think it's advanced enough right now. Now, the most common uses of AI by firms, they said generic non-legal AI tools such as ChatGPT or AI-powered legal research platforms, and then document drafting tools. So on the next slide, let's look at automation by AI. In 2023, Goldman Sachs conducted a study on AI automation and concluded that 44% of work tasks performed in the legal industry could be automated by AI, and that AI could potentially replace 40% of legal industry employees. This year's Legal Trends report dives into that question, undertaking what it called a more refined analysis that started from the same data that Goldman Sachs analyzed, but then it compared it to aggregated billing data from tens and thousands of legal professionals. It found that nearly 3/4 of law firms' hourly billable tasks are potentially exposed to automation by AI. The tasks with the highest potential for automation included documenting and recording information, just generally getting information, and then analyzing data or information. Those also happen to be the tasks that account for 66% of hourly billable work done by the average law firm. Meanwhile, the tasks least likely to be automated include providing consultation and advice and developing objectives and strategies. So this is all a lot to chew on, but on the next slide, I thought that this was another interesting piece of information. Most clients are copacetic to law firms using AI. This really surprised me, but nearly half of all clients would prefer to work with law firms that use AI, which suggests that they see AI as a means of offering better, more efficient legal services than firms not using AI. Cumulatively, 70% of clients are either agnostic or would prefer to work with firms that use AI, meaning that the vast majority of clients either want their lawyers to use AI or at least amenable. This number is likely to increase when we consider how quickly consumer attitudes surrounding AI use have shifted. In the 2023 Legal Trends report, only 46% of consumers said they were open to working with law firms that use AI-powered software. So let's now turn to when will Gen AI be a central part of your organization's workflow? This data on the slide shows, and this is taken from the 2025 Thomson Reuters Generative AI and Professional Services report, by the way. But the data on your slide shows that law firm data, when you're just looking at that first bar there under law firms, when you look at that law firm data, 29% of lawyers said within 1 year and then 34% said 1 to 2 years. So the surge in the number of legal professionals using AI marks a significant shift in how law firms are integrating AI into their daily operations. So I know I gave a lot of statistics and a lot of information here, but I always get asked a lot. We do a lot of presentations on AI. Lawyers are interested in learning what other law firms are doing and how they're using AI and if they're using AI. So we thought it would be important to share this before we jump into some of the risks of using AI. And with that, I'm going to turn it over to Joe to talk about some of the risks. Joe?
Good afternoon. Good morning, everybody. The interest in AI, I think everybody can agree, is probably something that's grown faster than anything that we've seen in our lifetime. Certainly, it blows away the internet rush back in the early 2000s. We started in 2019, and before anybody was talking about AI, and my initial problems were trying to get people to understand what we were, what AI was, and what it could do. And now my phone rings like it's never had before, because everybody on the planet wants to have an AI solution, whether they understand it or not. And that's the part that I believe is going to lead to an awful lot of problems for people if they rush to adopt something that they haven't really gotten a handle on. The inaccurate and unreliable part of generative AI is a much bigger risk than you can normally get out of the average AI guy, talking about his product or talking about the industry overall. When they talk about how an LLM, right, a large language model, can hallucinate, it's not just a matter of where they couldn't remember if the answer was 5 or 10, and so they just made something up and it got something wrong. They're actually capable of wholesale hallucinations, including creating entire conversations and scenarios with you, and which they will then act on, believing that as part of this scenario, this is in your best interest. And by act on, meaning if you have an AI in your system, because you've either taken something on from a vendor that has not truly explained to you ways to firewall truly sensitive data, instead of finding that you may have the wrong citations in a brief, you may find an entire folder or database completely wiped out, or you may find it completely changed with mock data, or data that the AI at that moment felt was easier to manage overall based on the project that you were working with. So, these things here they talk about, is an eager to please intern who sometimes lies to you. This is a gross understatement, downplaying. Sorry, this is a gross downplaying of actually how much you have to be concerned about when it comes to generative AI. Come on to the next slide. So why do these tools hallucinate? So the answers that they're given here are, they're an attempt at an answer, but the reality is we don't quite know why LLMs hallucinate. The way they are trained is very similar to the way that we were all told to take the SATs. Remember, don't leave any question unanswered, right? It's better to guess and get an answer on paper than to leave it unanswered. The way the models are trained right now is it's a shockingly similar type of scenario. So it's not that they're hallucinating. What they're doing is they're responding to the training that they've been given to say, I don't quite know, but let me go ahead and make sure that I'm giving some kind of an answer. So, and if you look up the CEO of Google, if you look at quotes from the CEO from OpenAI, not only will they not tell you they are unable to tell you why the models hallucinate, they're actually also unable to tell you how and why the models work. It is an enormous black box right now, and probably will be, because we're talking about billions of points of data to get these things to work, far beyond the ability for any normal human to be able to understand. You want to go to the next slide? So, are hallucinations really a problem? So again, the way this is presented, right? It presents it in a way where you just think, oh, I got the wrong answer, or I didn't get the answer that I was looking for. I got an answer on a topic that was completely made up. What this kind of glosses over is that every single major AI now, right, is equipped with things called agents, and those agents can perform lots of tasks on your behalf, right? And I'm sure a lot of people have taken advantage of it or signed up for subscriptions to open up your email, do some calendaring for you, and do some automated responses on different things. Once the AI is within your system, its ability to answer an email is not stopped by the fact that you told it, I only want you to answer emails that have this particular subject line. It can basically answer whatever it wants, however it wants, and those are really the problems that people need to be worried about. It's not the hallucination because they got the answer wrong. It's the hallucination when it decides, you know what, I'm just gonna take care of answering everything today, and because all this data isn't really well organized, let me go ahead and just put in some really well organized data, and it'll make my charts and my graphs more accurate. And I know I talked about the LLM in the third person as if it was somebody with an actual voice, but I can tell you that just a few weeks ago, while working on a project, and I have all of my stuff firewalled between our company data and the development work that we do, right? Working on a project, I was about 4 days in of straight nonstop, too much Monster energy drink to keep myself going, and was trying to solve a rather difficult problem in using one of the better AI agents, Claude, with a program called Windsurf. And all of a sudden, this problem, it worked. It started, the solution I was trying to put in place was working beautifully. And I didn't have any indication as to what happened or why. So I went back into history and saw in the coding that was getting from Claude that it decided that the task was just too difficult to be able to get finished in this particular time frame, and completely erased 4 days worth of work and thousands of lines of data, and replaced it all with mock data, mock patients, mock scenarios, all of it, so that it would fit and work perfectly with what I was trying to do. And it did that without any indication to me that this is what it was even thinking, but it just went ahead and put that in place. I have backups on everything, and this is not my first rodeo. but the level to which it went in and made those changes so it could make it work, maybe trying to please me, right, was just absolutely astounding. And so I would caution people to obviously you have to worry about the wrong citations. You don't want to put anything in front of a judge that you haven't read thoroughly yourself, but you need to be really careful about how you incorporate AI, and you need to be really careful about the vendor that you choose about bringing AI into your organization. There are a million people out of the blue in the past 18 months who are now on LinkedIn, all calling themselves AI experts. And some of the things that they say are a little bit off the wall. And when I talk to different law firms and I talk to different TPAs and insurers, because that's where most of my business comes from, I am just absolutely amazed at how little time is spent by these guys in putting walls up and preventative steps in place to make sure that their data is kept safe and secure. And it's just shocking how much that happens. And then next slide. Okay, it's back to you, Erin.
Yeah, thanks. Kate, do you mind just going back to that the previous slide? There's a couple things that I thought were important to point out. Joe brought up some great points, and I think when he said that AI it's like an intern that's eager to please, I think that couldn't be more accurate. So I'm sure there's some people that think that these hallucinations and things like that are blown out of proportion, and I think this slide's really important because you can see here from the numbers that these hallucinations happen all the time. So Stanford University's Human-Centered Artificial Intelligence Facility, it's one of the top AI labs in the world. They did a study last year geared specifically to AI tools in the law, and they posed the same legal queries to a number of popular legal AI tools. And you'll see on your slide, this is what they found. Over 1 in 6 of the queries caused Lexis plus AI and Ask Practical Law AI to respond with misleading or false information. Now, Lexis plus AI hallucinations happened about 17% and then 33% of the time. Ask Practical Law AI, they gave incomplete answers more than 60% of the time. Westlaw hallucinated substantially more. About a third of its responses contained a hallucination. So I just think it's important to point out that these hallucinations happen so much more than you would think they are, because they really are this, the AI, it's like they just want to give you the answers that you want. And I think Joe's example of that is a great one. They want to make you happy. So they're going to give you information, even if it's not factual, in order to do so. So we can move on to the next slide, but I just thought it was really important to point that out, because I think that's a misconception sometimes about how inaccurate the results can be, and then sometimes just fabricated altogether. So moving on, let's talk about some other risks, bias and discrimination. So I think another common misconception about the use of AI is that with the removal, or at least the reduction, of human decision-making, it comes then the decision will be clean, or at least implicit from any bias. We think robots are objective. They have no feelings, no preconceived notions. However, one of the primary ethical concerns surrounding AI in law is the risk of bias. As we've been discussing, AI systems often rely on historical data to generate insights. And if this data contains biases, whether racial, gender, socioeconomical, those biases can become ingrained in the AI's output. This can be due to factors like biased training data, algorithmic flaws, or human biases in the development process. It can manifest as discrimination against certain groups, perpetuating societal stereotypes, or leading to unfair treatment. For example, while chest pain is widely recognized as a primary symptom of a heart attack, women are more likely to experience fatigue, nausea, shortness of breath, or pain in their jaw or back. Yet, AI systems trained predominantly on male data sets, they may not weigh these symptoms appropriately, leading to delayed diagnosis. Also, in a recent study published in Nature Medicine, generative AI models recommended different treatments for the same medical condition based solely on a patient's socioeconomic and demographic background. Despite identical clinical details, the AI models occasionally altered their decisions based on a patient's socioeconomic and demographic profile, affecting key areas such as triage priority, diagnostic testing, treatment approach, and mental health evaluation. The only alterations were socio-demographic details, such as race, unhoused status, and LGBTQIA+. So the clinical information, it all stayed the same. The study also revealed that high-income groups were more likely to be offered advanced imaging, whereas low-income groups received fewer diagnostic options from AI. Predictive analysis can be discriminatory, skewed risk assessments, or subtly biased language in documents. And when this information is used in the practice of law, it can lead to unfair outcomes and perpetuate discrimination. So on the next slide, you'll see this is just a kind of a silly little quote, but I think it's so true when it comes to, is GAI the right tool for the job? You need to think carefully about what you are trying to do. Is AI the best answer? Are other tools at your disposal? Very useful, but you need to be intentional about how you're actually using GAI and incorporating it into your practice. Careless uses are always going to lead to bad results. And with that, we're going to talk about a case where this did end up with a very bad result for this particular lawyer. So this case that we're going to talk about, it's a very well-known case, and many of you probably know about it already. But in May of last year, a Manhattan lawyer became famous for all the wrong reasons. The attorneys admitted that they used ChatGPT to help research the brief in a client's personal injury case against a Colombian airline, Avianca, and unknowingly included false citations. Now, the lawyers for Avianca first alerted the court in March that they could not locate some of the cases cited in the brief. And, of course, the judge did not take kindly to this submission. Describing an unprecedented circumstance, the judge noted that the brief was littered with bogus judicial decisions, bogus quotes, and bogus internal citations. The legal brief included 6 fictitious case citations, all generated by ChatGPT. Now, the lawyer stated, "We made a good faith mistake in failing to believe that a piece of technology could be making up cases out of whole cloth." Well, the judge found that the lawyers acted in bad faith and made acts of conscious avoidance and false and misleading statements to the court, and ordered 2 lawyers and their firm to pay a $5,000 fine. But this was terrible press for the firm, and it certainly made headline news. The judge wrote in the sanctions order that there is nothing inherently improper in lawyers using AI for assistance, but he said lawyers' ethics rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. The judge also said that the lawyers continued to stand by these fake opinions after the court and the airline questioned whether they existed. The order also said that the lawyers must notify the judges, all of them of which were real, who were identified as the authors of these fake cases of the sanction. So, next slide. Post-Avianca, did lawyers learn their lesson? Not really. When we put these slides together, there were over 120 court cases that had been caught with AI hallucinations. Now, this was a couple of months ago, and I looked earlier today, and now there are over 247 cases. So this slide that you see, Ropes and Gray, they provide a map of standing orders and rules across the country. And if you are interested in looking about how attorneys are continually getting themselves into trouble in your specific jurisdiction, this is an unbelievable resource. So when I jumped on it this morning and saw that there were over 247 cases, I'm in Pennsylvania, so I'm licensed in Pennsylvania. I looked up just some recent cases where there were court-imposed consequences or attorneys getting themselves into trouble. And there was one in the Eastern District of Pennsylvania, and The judge's opinion in this case ordered sanctions against defense counsel for citing hallucinated cases due to the use of AI. The court found that counsel violated Rule 11 and ordered a fine of $2,500 payable to the court and required the completion of a 1-hour CLE credited seminar or educational program about artificial intelligence in legal ethics, followed by submission of a certificate of completion that clarified that they took this course. Now, the judge did say there is nothing in Rule 11 that specifically prohibits reliance on AI for research assistance, emphasizing that the court does not take issue with the use of AI, but rather the attorney's failure to be the final auditor for all legal and factual claims contained in their motions is what got them in trouble. So outside of Pennsylvania, another one that I looked up that just happened 12 days ago was out of the Northern District of California. And this was one where plaintiff's counsel included various hallucinated and erroneous case citations in his motion for judgment under Federal Rule of Civil Procedure 52. In response to the court's order to show cause, the attorney admitted that he may have unknowingly copied case information from an AI overview on Google or another open browser tab that he intended to delete from the brief since he had not read those cases. While the court found that the plaintiff's attorney was in violation of Federal Rule of Civil Procedure 11 for submitting a filing with inaccurate and unreviewed assertions of the court's civil standing order for failing to recognize the use of AI in the preparation of the papers. As a result, the judge ordered the plaintiff's counsel to pay a $1,000 penalty, serve a copy of this order on his client, and submit a declaration to the court that certifies his participation in a CLE course on the ethical use of AI, and the clerk of the court to serve a copy of this order to the State Bar of California. So this just happened 12 days ago. So despite lawyers getting themselves into trouble, this continues to happen. So now what we're seeing, of course, judges aren't happy. They're trying to combat this new phenomenon. Sanctions are being imposed, just like the cases that I talked about. But some judges are actually issuing standing orders for their courtroom when using AI. They're requiring parties to sign as part of certification that they used AI responsibly and are double-checking sites. You're going to see on the next few slides, I just pulled some examples of this, but this makes sense. We do have a duty of candor as attorneys. So on this slide, you'll see this is Judge Starr's standing order that mandates attorneys to file a certificate on the docket attesting that either no portion of the filing was drafted by AI or that any AI-generated language was checked for accuracy by a human being. Judge Starr's order followed a situation where a lawyer used ChatGPT to prepare a brief, contained made-up cases, highlighting the potential dangers of relying solely on AI for legal writing. So very similar to the Avianca case that we just discussed. On the next slide, this is again from Pennsylvania. This here says, if any attorney for a party or a pro se party has used artificial intelligence in preparation of any complaint, answer, motion, brief, or other paper filed with this court and assigned to this judge, they must, in a clear and plain factual statement, disclose that AI had been used in any way in preparation of the filing and certify that each and every citation to the law or the record in the paper has been verified and is accurate. So we also see that judges are imposing these orders, but we also have a lot of state bars issuing guidelines regarding the use of AI. So we're seeing a lot of opinions coming out. For example, the State Bar of Texas, through its Professional Ethics Committee, they issued an opinion in February of 2025, and this opinion addresses the ethical implication for Texas lawyers using generative AI tools like ChatGPT in their legal practice. The opinion's core message is that generative AI can be a useful tool to enhance legal work, but attorneys must use it responsibly and ethically while still maintaining their professional judgment and responsibilities. So Texas' approach to AI in the legal ethics, it mirrors the ABA's formal opinion, which was ABA Formal Opinion 512, and it's essentially saying we're applying these existing rules of professional conduct to this new landscape of AI. Texas actually formed a task force, which I think is great. They formed, it's called TRAIL, but it's the Texas Task Force for Responsible AI in the Law. And they formed this task force to address the growing impact of artificial intelligence in the legal profession. And the task force has worked to identify ways that the emergence of new AI technology might affect the practice of law and how lawyers and also judges and the state bar should respond. I think we're going to see a lot of great things coming out of this task force. But other state bars, just more examples, the New York State Bar Association and the New York City Bar Association, they've both issued guidelines on the ethical use of AI as well. The key differences between the New York State Bar and the New York City Bar Association guidelines that I would say the New York State Bar, they offer a broader framework for AI ethics in the legal practice, while the New York City Bar Association's formal opinion is a little bit more specific, focusing on the ethical implications of generative AI tools. Now, both acknowledge the importance of lawyer competence and supervision, but this is really interesting. The New York State Bar's report explicitly states that refusal to use helpful AI may be seen as a failure to provide competent representation. That was the first time I saw that. So more to come on that, I think, for sure, but I thought that was really interesting, giving technology and the competency requirements that are instilled upon lawyers. So I think we'll be seeing a lot more of that in the future. So now that I've covered some lessons learned, I'm going to turn it back over to Joe to talk about confidentiality and the risk of confidentiality breaches in using AI. Joe?
Thanks very much for that. So let's get back to talking about the tools that we're looking to bring into our systems. We talked before about LLMs. First of all, no one really understanding how they work, and we have we think some good guesses as to why they may hallucinate. But this part here, the confidentiality breaches, right? The possible HIPAA breaches, the possible disclosure of attorney work product, is incredibly high here. And the worst part about it is that it can be done by an LLM, right, by a large language model, in a way that is completely that you're completely blind to. If you have people are very accustomed to hearing about the company that got themselves in trouble and had to pay fines because there was a virus on their system, and emails got sent out, or someone was able to access their system. Everybody's always familiar with the the ransomware, right, where somebody gets a hold of your system and locks it up until you pay them 50 Bitcoins or whatever their ransom is going to be. This is far more hidden and can be far more dangerous, because these breaches can occur as part of a hallucination where the LLM believes it's it's working on your behalf, it's trying to please you, it's solving a problem, it's being creative, like it was taught to be. And documents get sent out by email, by fax, by Dropbox share, but shared by OneDrive, all the different ways that we're all interconnected, and it doesn't have to tell you. And not only doesn't have to tell you, it has access to all the things that you have access to, meaning short of having to have a multi-factor authentication signal sent to your phone to log in into a site, which everybody these days really should have two-factor authentication on everything they log into. And if you don't, with all due respect, you're being irresponsible. But short of the LLM needing to have a text message sent to your phone in order to log in, they can access all the different sites and shares that you have and send and share whatever they want, and you won't be the wiser for it until it's too late, right? And so it's really important. It's really important that if your confidentiality rules take into account if you have any kind of generative AI in your law firm right now, that you take that into account and you prepare to deal with it and prevent it. Next slide. IP infringement. Erin, I'm going to let you take IP infringement. I'm not an attorney on this. The only thing I understand about the IP infringement is it looks like some cases are going against the people that are having their data modeled and being trained on. In some cases, look like it's going in their behalf. From my perspective, being on this side of the aisle, so to speak, with AI, cat's kind of out of the bag. Google and DeepMind and all these other big LLM companies, they've been training on all of our data for years. All of those free photo albums on Facebook, the United States since 2008, the entire world has been helping Facebook develop some incredibly powerful AI tools completely for free with their written permission based on the member agreements. But as far as the rest of the IP infringement goes, I'm gonna leave that to an expert like Erin and not myself.
Sure, yeah, I'll jump in here. So when it comes to IP infringement, I guess the good news, as you can see on your slide, under ChatGPT's terms of use, OpenAI assigns to each user all intellectual property rights the platform spits out in response to the user's prompt and in which the company may have rights. Well, here's the bad news. The content created by GAI, it might infringe on the ownership rights of those whose IP was used to actually train the platform. So is the use of copyrighted materials for AI training covered under the fair use doctrine, or does it constitute infringement? Over 30 lawsuits have been filed by copyright owners in U.S. federal court against AI companies, accusing them of direct copyright infringement for using copyrighted works without authorization to develop their AI models. The New York Times, they sued OpenAI and Microsoft just a couple of years ago, arguing that their large language models unlawfully incorporated the newspaper's copyrighted articles into their training data sets. The lawsuit claims that the companies used millions of the newspaper's articles without permission to help train chatbots to provide information to readers. A secondary argument is that it allows readers to circumvent their paywall. Just recently, Disney and Universal sued an AI image generator firm, Midjourney, in Los Angeles federal court, alleging that it violated the Copyright Act. The lawsuit claims that the company used and distributed AI-generated characters from the movies like Star Wars, The Simpsons, and some other films. Disney said that while AI has great promise when used responsibly, piracy is piracy, and the fact that it's done by an AI company does not make it any less infringing. So, bad news too, GAI creates its responses without specific attribution to the source or the sources in which it relies, sometimes verbatim. So you could be getting a word-for-word output from GAI that is plagiarized from copyrighted resources. Just because they pass through AI, it doesn't wash away the copyright. In response to these legal battles, lawmakers have begun crafting legislation to address AI and copyright concerns. One such proposal is the Generative AI Copyright Disclosure Act of 2024. Introduced in the U.S. Congress on April 9th of 2024, this bill would require companies developing generative AI models to disclose the data sets used to train their systems, increasing transparency and potentially giving copyright owners more control over their works. Violation penalties would start at about $5,000, and the legislation, it doesn't have a maximum penalty assessment necessarily, but we can say that we can see something like this happening and being passed. And I think a lot of people would argue that it should. So yeah, IP infringement is certainly a risk that we need to worry about when using AI in the legal profession. With that, Joe, I think I'm going to toss it back over to you to talk about internal policies to consider.
Great, thank you. So here you can see on the slide, it's talking about creating a description for the project, right? A lot of times I will have conversations with people in organizations where the push for AI is coming from the top down, and it's more of sometimes it's an ego implementation, but oftentimes it's somebody just trying to make sure that they're staying ahead of the curve and keeping the higher ups above them happy that they're implementing AI in their organization. I think one thing that's is really critical is that for this kind of technology, it's the people on the front lines of whatever business it is that wants to implement it. In this case, when we're talking here with you guys as law firms, is that the use case for AI really should come from the frontline people who handle the documents, have the customer interactions. Let them guide the discussions on what kind of AI solutions are actually needed. You will get a more focused product and a more focused approach by doing that. You'll have employee engagement in the AI process as opposed to an immediate pushback and looking at it as a threat to their jobs. And then you'll have a better spend of your AI dollars overall. The second thing is that you really need to make sure that you're engaging with someone that's helping you explore the different risks. And if you can't mitigate every risk, but you should be aware of as many of them as you can be. And if the only risk that your AI vendor is talking to you about is that the AI can hallucinate and give you wrong answers, you got the wrong group of people on the phone or in your room, and you need to shake their hands nicely and send them on their way and find someone else that can really make sure that they have your back and they're protecting you. Next slide. What can AI be used for in the practice of law? There's been AI use for contract review for years. Okay, summarization, contract summaries, contract drafting, legal research. AI has been out impacting these parts of the law for a long time. What's different now, right, is the use of generative AI to create content and product for you that you're going to put out. And if you're going to use AI, what you decide to use it for in these areas here, right, research, contract drafting, that's very much going to influence your safety and your policy discussions. One of the things that I tell my clients, again, most of whom are defense lawyers for the insurers or TPAs and insurers themselves, most of what I tell them is that it's important. It's important that you use AI to protect yourself as much as possible. And the way you do that is that you use AI in areas where it's really good and where it can't come back and bite you in the behind in the future. And in those cases, using it to prepare reports, identify discrete data, and patterns within the data and amongst large sets of documents. Those are things that AI can do really well if it's been built and prepared for by somebody that knows what they're doing. And it's done in a way that doesn't put you at risk for hallucinations, doesn't put you at risk for creating citations that don't exist. And at the same time, it becomes a real partner for you and your practice. When we were building our platform, back in 2019, and we would meet with lawyers. And by the way, a lawyer, Hector Benjamea in Los Angeles, he was my very first order. So every year I buy him a nice bottle of tequila that he likes out of Mexico, imported, to thank him. People were telling me, "Oh, you're an idiot. Lawyers are never going to want to use your product. They never use your product. Lawyers want they don't want the efficiencies. They get paid by the hour. They want to grind. It's what benefits them." And then I was at a CLM, College of Litigation Management conference in Chicago in May of 2019, I think it was. And I was still kind of building things in my head and hadn't really coded anything yet. And every breakout session, regardless of the topic was, all devolved into discussions with the lawyers complaining about how every bill they sent in, no matter what they did, was getting redlined by their clients. Every bill, everything they sent in was getting redlined. And if you stop for a minute, right, and you keep that in mind, and then you think about the average personal injury case or the average workers' compensation case, or med mal, there's more documents and records that are being generated to these things than anybody can read. And everybody just kind of ignores it, but nobody's reading everything that's being put in front of them. Not the examiners, not the adjusters, not the lawyers either. Okay, there's just too many pages. The average law firm brings in every month somewhere around 3 years worth of reading material on the number of documents they take in with their new caseload. So every month you've got 3 years worth of data to read. Right? It's too much for everybody. So when I kept in mind those conversations with the CLM and the fact that the volume was there, it dawned on me that there's a way to partner with the attorneys so that they can get the data they need and spend their time preparing for defense as opposed to trying to find the information they need. So our system was built on entirely on the premise of finding everything that's relevant and indexing and summarizing it, and then everything that's not relevant, we index and summarize it with just as much detail. And the reason why I bring that up is that the right company prepares data for you, right? Prepares data for you in a way that will go over well with your adversary. When our defense firms send out documents, we instruct them how to let the opposing counsel know that there is just as much detailed index and summary on all of the things that we say are not relevant to the case at hand, and that they're welcome to it at any time. And if they want to read through that and think that anything should be added back in, we're happy at our client's direction to add it back in a few moments without any charge. And after over 100,000 reports that we've delivered over the past 18 months, and from Malibu to Massachusetts, that hasn't happened once. And I believe the reason why I believe that is I think we've got a pretty good product, but it's a report that fits right in with your world, right? It's open, it's transparent, it's very easy to trace where the data came from and where the data is going. So in my mind, the best use for AI and the one that will cause the least amount of problems for attorneys is the research of the relevant points in the case, and not so much on the drafting and the writing. I know LLMs can write ridiculously fast, and they can write a 10-page brief in a couple of seconds to a minute or two, right? It's incredibly tempting to use. The reality is, though, you still have to read that. And the points that Erin was bringing up, and just out of a good practice, you're still going to have to read everything that it produced. You're going to have to look up every citation. Well, if you're going to have to do that much work on the creation of the document, in any case, you're probably not saving a whole lot of time, and you're letting you're letting someone who has never passed the bar actually write your documents for you, regardless of how well they can do on those on the tests that they give it. So where can AI be used in practice of law? Research and getting all the information out of the documents you have, so you don't have to spend your time combing through your documents to find data. You can review the data that's there and let the AI find the data that's there for you. I hope I didn't muddle that up too much. I'm over caffeinated today. Next slide. I'm going to let Erin share this lawyer story, because this is right up her alley here.
Sure, thanks, Joe. So Joe made some great points of what can AI be used for in the practice of law. I would just add to that, I think that some of the things that it would be beneficial to use it for is, say, the first draft of a litigation hold letter, or the first draft of a contract, or the initial template creation, or initial drafts of even discovery requests. These are all things that I think it's really helpful for, and to Joe's point, but you need to read them and make sure that these documents look good, and just don't rely on the bot. But on this slide, this is kind of an interesting case as far as highlighting what AI should not be used for in the practice of law. What you'll see here is this was a case where a judge on a New York State appeals court was outraged after a plaintiff tried to use an AI-generated avatar to argue his case. So this gentleman that you see on your slide is not a real person. The man didn't have a lawyer, in hopes that the AI avatar would deliver a more polished argument than he could. So again, this is not a real person. Needless to say, the judge was very confused and outraged when they find out what was going on. They thought that they were making a mockery of the court. So this is just a silly example of what AI should not be used for. But in reality, just to wrap this up, I know we're coming to the end of the presentation, some law firms may feel more comfortable issuing a ban and modifying their use policies once the regulatory landscape has fully developed. But at the very least, I think lawyers and firms must be aware that there likely will be a push to utilize these tools as clients, courts, and attorneys try to capture all the benefits of AI, because there certainly are a lot of them. But with that, I am going to toss it back over to Kate to open up our Q&A. Kate?
Great. Thanks so much, Erin. At this time, we'd like to welcome you to ask questions. So we're already receiving a lot of great questions. Let's start with this one. Does using an AI note taker during an attorney-client video call breach the confidential nature of attorney-client communications?
I can take this one, Joe. This is a great question, and I've actually been asked a lot about this on our risk management hotline. So using AI transcription and note-taking tools during meetings, it may inadvertently destroy privilege or expose privileged communications. And this is because these tools, they usually process audio in the cloud, meaning that a third party gains access to otherwise confidential attorney-client communications. So AI note takers, they could expose sensitive conversations to legal discovery and dramatically expand the scope of discoverable material. So saying all of that, my advice is that attorneys should prohibit automatic AI use in privileged meetings, restrict AI usage to non-privileged context, and then deploy AI locally or within secure firm infrastructures. So that's my answer to that question. But that's a great question, and I think we're going to be seeing a lot more come out of AI note taker and things along those lines.
Okay, great. Next, and we get this question a lot as well, how are firms billing for AI use?
I can take this one too, especially because we do a billing webinar and we're going to cover this, I think, extensively the next time we do it. But at this point, law firms are using kind of a mix of methods to bill for AI use. Some are passing technology costs on, or I've seen other firms that are actually adopting new alternative fee arrangements like flat fees, things along those lines. Whatever you're doing, though, I would say, I guess let me clarify too. When I say firms can pass the direct cost of using AI tools to clients, I mean they can do this by either a specific charge or they can build it into their overall fee. So that's what I mean when I say that they can pass the technology cost along. So that's something that we're seeing. And then again, things like flat fees along those lines. But I think the key really for firms is just to maintain transparency. You need to ensure the costs are reasonable. You need to apply with all of those billing rules that are in our professional rules and of obligation. And then you also need to communicate to the client what you're doing in an engagement letter. So whether you're passing the technology cost along or however you're adopting your new alternative fee arrangements that you intend to use for AI, just make sure this is clearly communicated to the client in the engagement letter so there's no hidden fees and the client understands what's going on and what they're being billed for.
Okay, perfect. And Joe, you kind of touched on this one a little bit, so you may want to take this one. Do you advise clients to adopt an AI policy for use of AI in their workplaces?
Yeah, I think if you don't, you're setting yourself up for your own lawsuits. The ease with which you can access AI it's shockingly easy. You can download any of the LLMs and get access to them right on your phones. If your employees are able to do any kind of an installation on their office machines, on their laptops, or on their desktops, if they access and install these things on their personal computers and then access company resources from their personal computers, all of that is puts the firm at risk. So there needs to be really clear expectations about how you're going to handle your security, how you're going to handle installation policies, usage policies. You need to take a serious look at what you want to do with that, what kind of risk you're going to accept, and you're probably going to need somebody that can help guide you along the way to let you know what's a real concern and what isn't so much of a real concern.
Okay, great. I think that's really helpful advice. At this point, we are out of time for further questions. I would also like to thank our speakers, Joe and Erin. Thanks so much. Have a great day.